Hey, I'm Rachel Kugel. I'm the owner and founder of the Kugel Law Firm, where we focus on DWI defense. We don't judge you, we don't lecture you, we defend you. And I'm here today answering some frequently asked questions that I get about New Jersey DWI defense. So let's jump right in. The next question I wanted to address is, what does the state have to prove in order for you to be convicted of a DWI or DUI in New Jersey? So in order for the state to convict you of DUI or DWI in New Jersey, there is two things that they have to prove beyond a reasonable doubt. The first is that you operated the motor vehicle, and the second is that you operated the motor vehicle while you were intoxicated or impaired by alcohol or drugs. So how can the state do that? Well, in some cases, in most cases, it's very simple, right? The person is driving, they get pulled over for speeding or swerving. They're obviously driving and operating the vehicle. And then they go back to the station, they blow 0.08 or more. And, that gets them the second element. So in some states, in some senses, it can be simple to prove it. In other circumstances, it can be a bit more complicated. And it gets more complicated because sometimes the state has problems on either one prong or the other, the operation element or the intoxication element. So sometimes the state has a problem proving operation. Sometimes an individual is behind the wheel, asleep, parked. A person could be in their driveway. A person could be in their home, and the police could have received a call that they had been driving erratically earlier. So you can imagine there are all sorts of scenarios in which and fact patterns in which the person isn't pulled over and is instead presumed to be driving or operating the vehicle. Operation, which is what the state has to prove, is a legal term in this instance that's broader than the term driving, meaning under the law in the state of New Jersey, the police don't have to see you actually move or drive the vehicle. It can be enough to be behind the wheel with the keys in the ignition. It can be enough for witness statements that you were driving. It can be a much harder case for the state, but it can be enough. So first, they have to prove operation. Sometimes they may have issues with that. Second, they have to prove intoxication. And like we said, sometimes that's straightforward and they have a per se case, a blow of 0.08 or more. Well, sometimes it's not so straightforward for a few reasons. One could be that there are problems with that 0.08 or more reading that call that reading and the truth of that reading into question. Perhaps the machine didn't work. Perhaps the state can't prove that the machine was functioning and operational. Perhaps the state can't admit that reading into evidence for some foundational or documentary reason. So there could be a problem with the evidence that the state has on that per se, reading of 0.08 or more. There could also be issues where a person refuses and there is no reading, or a person is unable for some reason. They could be unable to fully expel deep lung air, unable to give a sample, or unconscious, or there's all a variety of reasons that for some reason or another, the state does not have a reading. And in that case, the state can attempt to prove the intoxication element of their case based on observations. Observations are how a person looked or acted or what they said. This could be how they performed on field sobriety tests. It could be statements they made. It could be video evidence of how they looked and were unable to stand. And again, it could also, as I indicated, be statements about how much they've had to drink. Observation evidence where an average person, a fact finder, a judge, could look at the evidence in the case and could find beyond a reasonable doubt that that person appeared to be impaired by alcohol or drugs. It could also be, the manner in which they drove, right? If someone is up on a curb or parked in a strange way, or, you can imagine a fact pattern in which the manner of driving could potentially add to the evidentiary information that the state has to prove somebody is impaired beyond a reasonable doubt. So suffice it to say, what the state has to prove beyond a reasonable doubt is that you operated the vehicle and that you did so while in an impaired or intoxicated condition. And, there can be issues with that. So don't just take for granted that the state can prove it. Definitely, this is a time where you want to speak to an attorney. You want to go over the discovery, the evidence in the case with your attorney and see what is exactly the weight of that proof. What are the weaknesses in the state's case? And how might your attorney come up with a strategy to hold the state to their standard of proof beyond a reasonable doubt and point out to the state, either through negotiations or through trial, that they really can't meet their burden. So hopefully that answers that question for you. It's complicated, as many things in law are. And so I urge you to seek out counsel, whether it's me or somebody else, to go over this with. We're always here for you if you want to talk to us about it. And go over it and find out what your rights are and hold the state to their standard of proof beyond a reasonable doubt.